Good morning, everybody. We're just letting people in from the waiting room. I'm just going to give you a minute just to get comfortable. You won't be on the screen today. You'll be able to see Alan and myself, and then shortly I'll hand over to Alan. We're really pleased to have Alan with us today. Thank you for your time, Alan. Looking forward to hearing from you. And this is going to be recorded. You won't be on camera. And any questions, we will look at that in about 45 minutes so Alan can answer any specific questions that you have about your practice. And yeah, hope you enjoy the webinar. Really looking forward to it. So I'll hand over to the very capable Alan.
Thank you very much. And good morning to everybody. And you're going to have to bear with me whilst I get my presentation back up on screen. And if you've got any problems with viewing it, then please shout. I'm not the best person when it comes to IT, so bear with me. But if there's a problem with viewing, give us a shout and we'll get it sorted out. So bear with me while I get this back up on screen. Here we go. So, yeah, hopefully you can all see the slides. You should be able to see criminal compensation orders and my name. If you can't, then please let us know. So if you're all sitting comfortably, I'll begin the story. And our story today is all about criminal compensation orders. And there was a question earlier on today about the application of what I'm going to be talking about to Northern Ireland. So, good question. My understanding is, and I'm not a Northern Ireland lawyer, what I'm going to be telling you does apply to Northern Ireland. I think there's some slight variations and the law's slightly different and the regulations a little bit different, but all the general stuff that I'm going to be talking about, I think will apply to Northern Ireland. But I'll repeat again, I'm not a Northern Ireland lawyer. So if you want particular advice about Northern Ireland, then you need to speak to a lawyer out there in Northern Ireland who will know a bit more about this and its application in that part of the country than I do. Right, so let's get going. Hold on. Why is my slide not moving? Yes, here we go. Victims Code. So you've got to remember that the Victims Code sets out the minimum level of service victims can expect from the criminal justice system, agencies such as the police and the courts, whether they choose to report the crime or not. And the Victims Code is now on a statutory footing, so it's the law, so to speak. And the new code is structured so it focuses on 12 overarching rights. And I think we need to be aware that the code could change again. It's been through several variations. But the important thing is that you working with survivors and victims must be conscious of the Victims Code, and those that you're working with also need to be conscious of it. And you can never assume that they are conscious of it. I'm still surprised by the number of people, whether it's police, CPS, whoever it happens to be, haven't actually got this at the forefront of their minds. So you can't assume anything, but you have got the obligation, the same way as I have, to make sure that it is at the forefront because it's so important. And as I said, it focuses on 12 overarching rights, all to help victims and survivors to have access to the justice system, basically. But we can't spend all day talking about the Victims Code because we'd be here all day. So I'm going to be talking about Right 5, which is for the survivor or the victim to be provided with information about compensation. And the Victims Code focuses on victims' rights and sets out the minimum standard that organisations must provide to victims of crime. So that means that victims and survivors must be provided with information about compensation. It's not pick and mix, it's there and they must be told. And it's up to the victim or the survivor to decide what they want to do with that information. So we're going to be talking about compensation, and from a survivor perspective, compensation may, and I emphasize may, arise in a number of ways. And we're going to be talking primarily today about criminal compensation orders, which is where the criminal court, the Crown Court, makes a compensation order. But we also need to be aware, of course, that when we're interacting with survivors and victims and giving them information, that there are other sources of compensation. The Criminal Injuries Compensation Scheme, CICA, I'm sure you're all familiar with that. Sometimes there are bespoke compensation schemes for particular groups of survivor. So in Jersey, out in the Channel Islands, there have been 2 compensation schemes for survivors. There was a compensation scheme here in London for survivors in Lambeth. Northern Ireland scheme set up by the government compensating survivors in the care system in Northern Ireland. Similarly, the Scottish devolved government set up a scheme that's up and running there. And there was a Manchester City compensation scheme for victims and survivors of sexual abuse under the sort of Manchester City Football Club umbrella. And then you have civil claims for compensation, which is where Bolt, Bird and Kemp in particular are involved, and that is where survivors and victims bring their own claims for compensation, either against the abuser or those responsible for the abuser. So this is where they're bringing their own claims, okay, against the abuser or those responsible for them. But we're going to be talking about the first one here, criminal compensation orders. The Sentencing Act 2020 basically says that when sentencing an offender, the judge must consider, emphasize must consider making a compensation order, in other words, ordering the offender to pay compensation to her victim. And they are under a duty to give reasons where a compensation order is not made. And this is statutory. It's the law. So let's say someone burns down my garden fence, commits the offence of arson. So when the judge sentences the offender for criminal damage for the arson, burning down my garden fence, the judge must consider ordering that person who burned down my fence to pay for the damage. So, it may have cost £1,000 to replace the broken, burnt down fence. And the judge must consider ordering that offender to pay £1,000 to me for the damage that the offender has gone and caused. And that is part and parcel of the sentence. So the offender may go to prison, may be put on community service, but as part of the sentencing, the offender's got to pay compensation for the arson. So that's a very simple principle. And if the judge doesn't do that, the judge must explain why she hasn't done that. And as I said, it's the law. It's a must. It's not, pick and mix. And the sentencing code, which is the sort of guidelines that judges and magistrates have to help them do their job, says the court must consider making a compensation order in any case where personal injury, loss, or damage has resulted from an offence. So you've got the law and you've got the guidelines that judges have to help them do their job. It makes it very clear they must consider making a compensation order. And so it doesn't matter whether it's criminal damage, theft from an employer, someone's had their hand in the till, or sexual abuse. There's no distinction. But as we will find out, when it comes to survivors and victims of sexual abuse, they are treated very much inadvertently like Cinderella at the ball, so to speak. And we're going to be looking at that. There are very few orders made in sexual abuse cases. So ICSA, the Independent Inquiry into Sexual Abuse, looked at all of this and found that in 2017, only 26 orders were made by the courts where there were 6,861 offenders of sexual abuse. So 6,861 offenders of sexual abuse, abusers, were dealt with by the courts, yet only 26 orders were made to compensate their victims. And this begs the question, why so few? And questions have been asked in Parliament, not recently, but a couple of years ago, about, all of this. And there seems to be a lack of awareness. Well, there won't be a lack of awareness now because you guys have come on this course. And 10 out of 10 for that because you are leaders in all of this now. But there's a general lack of awareness. Police seem to forget about it. And because the police and the CPS forget about it, the judges forget about it. And survivors, of course, it's like the blind leading the blind, if I can put it crudely, because survivors won't know anything about all of this because they're dependent on people doing their jobs. They're dependent on the police officers completing the paperwork properly. They're dependent on the CPS and they're dependent on the judge, all doing what they're supposed to be doing. And it could be that sexual abuse is somehow seen as different, difficult, but that's no excuse really. So when ICSA was taking evidence from survivors about all of this, there was one gentleman, his abuser was a notorious one and got a life sentence. And this survivor was in court when sentence was being passed. So everyone was on, yes, too right, this offender's getting a life sentence. But this gentleman pointed out that when the offender was in the dock being sentenced and being sentenced to life, he noticed that the offender was wearing a Rolex watch. And he thought, why wasn't that being confiscated? Why couldn't that Rolex watch be confiscated and auctioned, sold, or whatever? And, the proceeds, distributed to survivors. Very important question. Pretty profound question too. Didn't happen because everyone forgot about it. Police didn't do anything, police didn't say anything, CPS didn't say anything, and of course, because they don't say anything, the judge doesn't say anything. And it just seems as though survivors are, in some respects, sort of second class in this stage of the process, and they shouldn't be. And this is why we're putting on this course today, to try and swing the pendulum a little bit back towards survivors. Some judges are excellent. So when we last did this course, Anisva pointed out that she'd recently had a case where the Crown Court judge in Nottingham, I think it was, went out of her way to do all of this and ordered various inquiries to be made about the offender's circumstances. And I'm sure Helen would remember this. The judge went and ordered the offender to pay something like 50 or 60,000 pounds to the victim. And that was sort of unheard of. But that judge was an excellent example of how this needs to be done and how to do it properly. So anyway, moving on, as I said, it's maybe, sexual abuse cases are seen as different. And there's a sort of hesitation, I suppose, in my experience, that it's hard to quantify how much compensation should be ordered, and perhaps there isn't enough guidance. But I think there's loads of that around to help the CPS and the court and the judge. So we're going to go on to that in a moment. So this is the path that we have to travel down. Okay, so I'm going to take you through these various stages. So the court must consider making a compensation order where there has been personal injury, loss, or damage. There's no limit on the amount of compensation that can be awarded by the court, and compensation should benefit the victim or survivor and not cause them any harm. And the police are to discuss with the victim beforehand and obtain information and views about their position and what they think. And the police have to complete a form called MG19. and I'll try and show you MG19 when we finish this PowerPoint. I don't want to do it at this stage in case I go and mess up the slides. Um, but I can send you a copy of MG19 anyway at the end of this. It's a very simple form. Anyway, so the offender's means must be considered and the order made by the judge must be realistic. So if the offender hasn't got a penny to their name, then quite clearly it's a waste of time, the judge ordering the offender to pay compensation. We all get that. And, one's got to be realistic. It's no good ordering an offender who hasn't got a penny to their name to pay, £10,000 or whatever it happens to be. It would be insulting to the survivor, wouldn't it? Because it'd be just totally unrealistic. So the offender's means must be considered. But offenders often do have means. They often do have assets. They often do have a property which can be sold and the proceeds used to to pay compensation. If the judge doesn't make an order, the court must give reasons for not making an order. And the fact that the survivor or victim could go on and apply to seeker or to make a civil claim is not a reason to make a compensation order. So sometimes you hear judges say, oh, well, the victim can go off and apply to seeker. No, that's not a good reason not to make an order. Seeker isn't there to subsidise offenders. Seeker is a taxpayer-funded scheme, and it's there to compensate victims of crime. But the fact that it's there is not a good reason for the judge to say, I'm not going to bother to make the offender pay compensation. It's irrelevant. And all this is set out in the Sentencing Act 2020. So that's the path that we all have to travel down, okay? Compensation is to put the victim in the position they would have been had the wrong, the sexual assault, whatever that was, had not happened. So it's to compensate for the pain and suffering. So as we know from our work with victims, they can often suffer physical damage as well as psychiatric damage. And that the law says they're entitled to be compensated for that. It's a very ancient principle that goes back 1,000 years. It's been part of our law for centuries. It goes back to Anglo-Saxon times. General legal principle. And as we know, victims and survivors can suffer loss of earnings as a result of what's happened. So they can claim compensation for that. And in some cases, there may well be care costs, loss of education that has to be paid for, maintenance, dependency, particularly if they're young or that the damage is so severe, they can't live independently, they can't go to work. Sometimes in very severe cases, particularly with some children who've been subjected to really serious sexual abuse over a prolonged period of time, they may need care and they may need accommodation. So it can be very comprehensive. And it's not just about, paying someone a few pennies. Not at all. That's insulting and doing an injustice. Compensation is there to put the victim in the position they would have been had the sexual assault not happened. Primarily, we're talking about pain and suffering, but in lots of cases, there can be these other aspects to their case, loss of earnings, loss of education, and so on. So we have to think about all of these things when we're talking and having a conversation with the survivor. Unlike seeker, and you'll all be familiar with seeker, it's tariff-based, there's a cap. So when the courts are ordering compensation, you don't have this problem of a tariff or a cap or eligibility criteria, or the fact that the survivor or victim may have a criminal record and so on. So seeker is very prescriptive. It has very particular rules. Often we say unjust rules, but they're the rules laid down by Parliament. There's a tariff. It's, one size fits all type situation. But when courts are ordering compensation, we don't have to worry about the tariff or a cap or the eligibility criteria. So compensation, when the courts are ordering compensation, the courts are looking to see what has been suffered by the victim or survivor. So when we're looking at the pain and suffering, the physical and psychological damage, in our law, the victim is entitled to be compensated regardless of proving that they've suffered some psychiatric damage. If someone comes along and punches me on the nose, I'm automatically entitled to be compensated. If you go and hurt someone, the law expects the person who's done the hurting, forgive the grammar, to pay the compensation. It's a general principle. But when we're looking at sexual abuse cases, we're aware of the physical and psychological damage. And the general awards can be anywhere between £10,000 and £140,000. And where the survivor fits in that range depends very much on the seriousness of what has happened and the effect. Quite often, we see cases where the psychological damage is lifelong. It may improve with some treatments and so on, but it might be lifelong. And of course, that has consequences. As we know, it can affect ability to work, ability to have relationships, and so on. So that all has to be studied very, very carefully. And where the survivor fits in that sort of range depends, as I said, on what's happened to them and the seriousness of the consequences. And then we're often looking at financial losses, for example, wages. Survivor hasn't been able to work, so they may be out of pocket by, a couple of months' wages, if not longer. Then there may be treatment costs. As we know, getting access to treatment on the NHS is very difficult. And so often survivors need to go privately, and that all has to be paid for. And if they are going to have to pay for their treatment, that forms part and parcel of their claim. Okay, so we're talking about really two types of loss. There's the sort of physical and psychological damage, and then you've got the financial consequences. And judges and us, when we're thinking about all of this, need to be looking at what the judges have in front of them, which is the sentencing guidelines. And it helps them. So as I said, there's information available. So going back a little bit, I think it's important to remember that when we're dealing with sexual assaults, you've got the physical aspect, the violation, the injuries, and then you have the psychological consequences. PTSD, depression, anxiety. And so, there's that. It's very important that we remember those aspects. And we need to remember that nothing stays still and offending is changing. We've got offending being committed online, harassment, image sharing, and so on, which can all have profound consequences for the person receiving it, the victim. Someone being sexually harassed at work, that can have enormous consequences for the victim. They may end up, not being able to go to work. They may be suffering from PTSD as a result of what has happened at work. So we need to be conscious of the fact that offending doesn't stay still. It evolves. And with all of that in mind, we need to be thinking, right, if the offender's going to be sentenced, what information do we need to get in order to assist the court? So this is what we need to be thinking about, as well as the police, of course. So, and remember, with sexual harassment, it is unwanted behaviour of a sexual nature. Not only are these criminal offences, they are also rights in civil law giving rise to a claim for compensation. But remember, we're dealing with criminal compensation orders today, and we need to remember that sexual harassment is unwanted behaviour of the sexual nature and can be part and parcel of a criminal compensation order in just the same way as any other sexual offence. So, getting back to what the judge has to think about, compensation should benefit the survivor. It shouldn't inflict further harm. Sometimes survivors and victims will say, I don't want a penny from my abuser. But you need to give them the opportunity to think that through and make sure it's not a knee-jerk reaction. Okay? What does the victim think, not what I think? Okay. Victims need to be put in a position to make an informed decision. But at the end of the day, the victim's opinion should be respected. But remember, the victim needs to be put in a position to make an informed decision. So if they go and say, because they've been surprised, for example, by someone saying to them, oh, the judge may make a criminal compensation order, it wouldn't be at all um, surprising for the victim to turn around and say, I don't want a penny from that awful individual. But they need to be put in a position to make an informed decision about all of that. So, give you a little story. Some years ago, this was through an ISBA, a young lady was referred to me. She had been sexually abused by her father, been used as a drug mule by him, and she'd stopped going to school by the time she was 12 as a result of what was happening. Anyway, cut a long story short, he ended up being successfully prosecuted and received a life sentence. Anyway, so good result, but this young person was, through her ISVA, put into a position where she was able to make some informed choices about what she wanted to do. Justice for her was not just about seeing her so-called father go to prison, but she wanted him to pay for the lost education that she had. So she stopped going to school at 12 and she wanted to get her GCSEs, A levels, and go to university. Bit of a tall ladder to climb, that one, but that's what she wanted to do. And so she sued her father in the High Court here in London with the support of her ISVA and through us representing her. And her father was in denial and trying to continue controlling his daughter from the prison, so to speak. Oh, I don't have to pay any compensation. You know, basically he was saying get stuffed to the judge. But the judge said, no, you are going to pay compensation, and you're going to pay that compensation out of the proceeds of your crime. So this wretched man had made a lot of money out of, you know, his drug business. So the judge confiscated the money that this wretched man had made, and that money was used to pay compensation to the daughter, to my client, which she then used to pay for her education. So she went off to college, got her GCSEs, A levels, and she went off to university to get her degree. So for her, that was being put into a position by the support of her ISVA to make an informed decision about what she wanted to do. She wanted, for her, having thought it all through, wanted her father to provide meaningful justice, which was to pay for her lost education. So that's a little story, a true story, of course, but a very informative one, which demonstrates why it's so important to enable the survivor to think through all of this. Okay? But at the end of the day, it doesn't matter what I think or what you think, it's what the survivor thinks and what they want, and their opinion should always be respected. So the procedure for making the criminal compensation order. So the prosecutor has the duty to assist the court and remind the judge of the obligation to consider compensation. So there should be the victim impact statement, which we're all familiar with, and that statement can set out the effect of the sexual abuse, and it usually does. In my experience, you usually see very good victim impact statements. But the police should also complete Form MG19. And as I said, if we get the chance, we'll look at that. But it's a very simple form, which basically says, you know, this is what's happened to the victim, you know, whether it's the garden fence that's been burnt down or whether the victim has been physically and sexually assaulted. And with the MG19, there must be some information, maybe a report or a letter from, you know, a psychiatrist or the GP or whoever it happens to be, giving some informative information. And the judge has to listen to representations from the Crown and also from the defence lawyer, and then make his or her decision. If there are complex issues, then that may cause the judge to decline to make an order. Remember, there's no statutory limit. The fact that the offender has been sent to prison is irrelevant. The ability to pay is relevant. And compensation has priority over a fine or a surcharge. The fact that the victim can make a seeker claim is irrelevant. Likewise, make a civil claim is irrelevant. Double recovery. Always remember that the law in this country, a survivor or victim cannot be compensated twice. So in the very unlikely event, the survivor's already received £50,000 compensation from the abuser, the judge is going to say, well, the victim's already had £50,000. That's a good reason for me not to make a criminal compensation order. Okay, so I've put that in there because you need to know it, but I've never heard of that situation arising, and it's certainly, it's very unlikely to arise, but it's a legal principle that we all have to be conscious of. So compensation, remember the judges have sentencing guidelines to help them. It's a starting point. They can also look at seeker and see what victims can receive if they have a successful seeker application. And, sexual abuse of an adult, non-penetrative overclothing, starting point is 1,000. Sexual abuse of an adult, non-penetrative underclothing starting at 2,000 and so on. So, it's judges have access to information. It's there. And, there's examples, in the seeker guidelines, in their rules, B9, I know it's all sort of sterile language, which is a bit unkind sometimes, non-consensual penile penetration, 11,000. So, there's information there for a judge. They're not helpless. They can see all of that to help them. So I said, if the case is complex, the judge may say, well, I can't make a criminal compensation order. So absent, I think, a clear and simple case, you can expect pushback from the judge. But the prosecutor's job there is to help the judge navigate all of this. But the judge may say, well, it's a complex case and really the survivor ought to go off and sue the offender or those responsible for the offender in the civil courts. But what could be complex, I think in my experience, a complex case where a judge may be hesitant is where you've got very serious medical issues and it's very difficult to work out what's caused what. And you'll be aware, of course, that sometimes with victims and survivors, their medical background can be very complex. And you get cases where they've been subjected to multiple abuse by multiple abusers, and trying to untangle all of that is difficult. And a judge may say, I can't do it. I haven't got the information to enable me to unravel everything. But they need to think it through. They need to think it through before making that decision, and they must be encouraged not to make a knee-jerk reaction. Even in where there's multiple abusers or multiple sexual abuse involving multiple abusers over maybe many years, in itself, that should not be an excuse not for the judge to order something. Not to order something. The judge could say, well, I'm going to order the offender to pay, I don't know, pick a figure, £5,000. I appreciate that that's not doing justice to the situation, but on the information available to me, I think that's fair and reasonable and so on. And then it's up to the survivor or victim to go off and get legal advice about suing the offender or whoever's responsible for the offender to ensure that they get proper compensation. So, post-sentencing, regardless of whether a criminal compensation order has been made, victims and survivors should be aware that they might be able to make a seeker claim and they might be able to make a civil claim. The fact that a criminal compensation order has been made isn't the end of the road. Okay, as we know from lots of experience of dealing with the police, they think make a seeker application and that's it. No, police and everybody should be aware seeker is not the be all and end all. There are often, not always, often other options available to the survivor, and they need to be made aware of that. Likewise, always remember, even if there's not been a conviction, therefore a criminal compensation will obviously cannot be made, but that the survivor and victim may still nevertheless be able to make a civil claim or a seeker claim. So conclusion, criminal compensation orders are there to be made. And remember, it's all about giving some justice to the survivor, no matter how imperfect that justice might be. Victims and survivors need to know so that they can make informed choices. And there's no reason not to make a CCO in non-complex cases. In the real world, we need to expect pushback in complex cases, but we need to make the effort. The police need to provide the CPS with as much information as possible, and the CPS need to remind on sentencing the judge's power must make an order, and if the judge is not going to make an order, must explain why, and the CPS must ensure that they can put as much information in front of the judge as possible so that he or she can make an order and not decline to make one. So thank you very much. So over to, let's see if I can show you this form. Can you all see application for compensation? Someone let me know.
Yep, we can see that, Alan.
Yeah,
Perfect.
you see the form, okay, because I can't see you at the moment. So this is the MG19 that the police have to complete. So you'll see at the top for police use, RV, which will be Rex, versus name of offender and the offence and date of the offence. Compensation form, notes for guidance. So that is all self-explanatory. So as you go down the page, the first page is about property damage. So that's not going to be of any relevance, I would have thought, to us. Other expenses, lost fares, loss of earnings, that type of thing. So you can see here, loss of earnings, unpaid time off work due to injuries. That would include us. And then the relevant bit really for us today is personal injury. Describe your injuries. So I would expect to see there, as a result of the whatever's going to happen to me, I have been diagnosed with PTSD. It's considered to be severe and it's been recommended that I have treatment. And I've been told that I've got to pay for the treatment and it's going to cost £2,000. Attached is a letter from my GP or my psychologist or my psychiatrist explaining all of this. Okay, so describe your injury. So a lot of detail needs to be put into that. Details of medical treatment received, if any. And then you've got name of consultant or doctor, because there's no reason why the CPS can't write to the doctor or the consultant to get a bit more information. So it's all there for the police to complete and not just put a line through it. Insurance details, well, that's not going to be relevant to us. Details of the claimant, that's the survivor. Victim personal statement, yeah, so we all know about all of that. So, as I said, the relevant bit is this section C, personal injury. D, describe your injuries. I'm suffering from PTSD as a result of what happened to me. It's severe. My consultant says I need treatment. Please see attached the letter from the consultant or the GP, details of the medical treatment received. So as much information as possible. And, and this can be reflected as well in the victim impact statement. The PTSD may mean I have flashbacks. I can't watch television. My relationship with my partner has been affected because of. I cannot have intimate relations with my partner because of I get flashbacks, I don't like being touched, all that type of thing. So that's an opportunity to put as much information on that form as possible, um, and so on. And in some cases, there may well have been physical damage, which is often very embarrassing, but it's an opportunity to put that. I'm sure you get cases like I do where there have been physical problems as a result of that survivor being abused as a child or as an adult. Violence may have been used and so on and caused lasting damage. There may be scarring. Describe your injuries. I have a scar on my abdomen. I have a burn on my abdomen. Here's a photograph. This was caused by my abuser stubbing his cigarette out on me. It's an opportunity to provide that graphic, personal information. So there we go. Let's get back to not sharing my screen. Hold on. Right, okay. Bear with me. Hold on. Right. Can you see me?
Still sharing at the moment, Alan.
Hold on. Right, okay. Stop share. Right, there we go. Hopefully,
Wonderful.
hopefully we are
That's worked.
back to the living world, so to speak. Right, okay. So I've been rattling away. Any thoughts or questions at
We
this
do. I'm happy to read
stage?
them out, Alan. Do you want me to read out
Yes,
these?
please.
We've got a couple of questions here. Are you happy for everybody to receive copies of these slides, Alan? I know.
Yes, I'll send the slides and the MG19.
Thank you.
And then none of us have got an excuse when the police officer says, oh, we don't do that. We just say, well, actually, here's the form for you to complete.
Perfect. Perfect. We've also got a question from Mark Stroud.
Hi,
Will
Mark.
criminal compensation orders not be just another way for defence barristers to create reasonable doubt? For example, this is about getting money rather than seeking justice, just in the same way that seeker is often used against our clients.
Well, the judge should, if that was said, point out, well, as actually, as part of the law, I have to consider making a criminal compensation order because the law says I have, and I wouldn't be doing my job if I didn't consider that. And of course, under the Victims Code, victims and survivors are required by Parliament to be given information. So the judge or the CPS barrister should stand up, lawyers should stand up and say, well, actually, it's part of the judge's law. It's no different, it's part of the sentencing that the judge has to do.
So it's something that the court would be aware of then, whilst the jury was still involved, if you like. So the jury can be made aware of CCOs, Alan.
Yes, in the same way as
Yeah, as
anything
seeker.
else. I've never heard of a defence barrister raising criminal compensation orders.
Hmm.
Yes, they obviously try and throw mud around by saying, "Oh, you're just making this allegation in order to get a bit of money out of seeker."
Hmm.
Well, they will do that. I've never come across any of them saying about that actually, because it's not in their client's interest to do so. Because if it all goes wrong, that he or she will have inadvertently reminded the judge, oh, I've got to make a criminal compensation order if this man's found guilty or this person's found guilty. So
Good.
it's not actually, I would have thought, in the interest of the defendant for their barrister, lawyer, to stand up and actually remind the court about CCOs anyway.
Hmm. Yeah, I'm with you. Okay, good. Thank you. Oh, we've got 12 questions now. You've all jumped into life. Let's have a look. Hopefully they're in order. Yes, they are. Good. So, Kieran, welcome, Kieran. So, can a victim claim both criminal compensation order and seeker at the same time, or are they only able to claim or apply for one of them?
No, they can do both. They can do both.
Thank
And it's
you.
not actually down to the victim to apply. The onus is not on the victim. The onus is on the system. It's on the judge, the police, and the CPS to do it. So the police are meant to canvass the view of the survivor, but it's
Mhm.
not down to the survivor to say, "Oh, I want to make a criminal compensation order." It's not. It's not in their gift. It's in their gift to make an application to seeker. It's down to the victim or the survivor to make an application to seeker. But it's reversed when it comes to criminal compensation orders. It's
Good.
for the judge. It's a judge initiated, but judges need reminding by the CPS, who need to be reminded by the police.
Thank you, Alan. Thank you. There's lots of questions coming in. Let me get my screen right. Esme. So Esme had a case. Oh, the screen keeps moving. Bear with. Esme had a case where the police officer applied for the judge to make a compensation order, but the CPS stroke prosecution rejected that, refused to submit that request to the judge. In terms of pushing back on a situation like that, is it only the police who can challenge that, or is there a way to do that as an ISVA?
Well, number one, I would make a complaint if that's what the CPS did, because it's not in their gift to decide whether or not to. You know, it's up to the judge to decide whether or not an order is going to be made. So number one, if that's what happened, then the CPS, in my humble opinion, were in the wrong.
Mm,
And the police should have been saying, well, the victim has been spoken to, and the victim wants the judge to consider making an order. And the barrister or solicitor, whoever it happens to be, the advocate should have said to the judge, you know, here's the victim impact statement, here's the MG19.
good. Yeah, thank you. Esme is also enjoying the training and thanking you, Alan. So thanks from
Thank you very
Esme.
much.
Hannah is saying, I have never heard of a compensation order being put in place locally. Do you have any advice on how to start the conversation locally as an ISVA service?
So can you, not sure I quite understood
She's
that.
never heard of that being put into place in the area that Hannah works
Yeah,
in.
well, it should be,
So,
but it is, as I said, well, you know,
yeah.
the statistics are appalling. You know, in 2017, what was it? Only 26
It's
orders in
crazy.
the country were made, and it's all down to can't be bothered,
Mm,
forget about it, that kind of thing. As I said, victims and survivors are Cinderella at the ball, and you know, they're having to run the gauntlet of, you know, everybody else, and it's not
mm.
on. And it's our job, in the nicest possible way, to remind police officers and the CPS, come on, you know,
Maybe we could forward
if
them
it's
this
garden fence
webinar.
that have been burnt down, you'd be putting in a one of these MG19 forms. Can you put in an MG19, please, for this person, this
Mm,
victim?
thank you. I'm just thinking, use this resource. We're going to be filming this and popping this on YouTube. You can forward this to your local officers that you're working alongside, see if that helps.
Mm.
Um, also the
You'll get
slide.
resistance because, you know, because for most of them it'll be, oh, I haven't done this before. And it's only when they start to see their colleagues
Mm,
in the police and CPS doing all of this, but might start to see a change of
mm.
emphasis and attitude. As I said, you know, one of your colleagues, and the last time we did all this, spoke of this
Yeah,
wonderful story up in, I think I'm sure it was Nottingham, where this judge had made this fantastic order. She really made the police and the CPS do their job
they
to
really
get
did.
the, she wanted the information.
Yeah, it was a lot of money, that one.
Mm.
Thank you. It's all gone into a little bit of a different order now, but I think that Anna is ticking them off the list when they're answered. So thank you, Anna. Um, let's have a look. So, Kaylin is asking, please may I ask in relation to double compensation? So, in your experience, does applying for seeker post CCO get much benefit? Are they awarded higher amounts than with the CCO?
Well, let us say um, a judge ordered a criminal compensation order and the offender was ordered to pay £5,000, and the offender paid the £5,000. Seeker may take the view that the sexual abuse was in, you know, in a really serious category, and may say, well, you would fit in on, I don't know, the £27,000 tariff. They may turn around and say, we're going to offer under Seeker £27,000, but you've had £5,000 in respect of part of what happened to you. So we're going to deduct that, so you get 22,000.
Mm-hmm. So that's
Okay.
27. Yeah, good. We've got a question here, and this is Anna posting on behalf of an attendee. One of my clients has reported sexual abuse from childhood. Apologies, my screen's moving. If there isn't enough evidence to go to court, will they still get compensation? And also, when completing the form, it doesn't state about education, care, work, etc. As it asks for, all it asks for is for the client disclose this to the professional such as GP, and if so, they would like copies of evidence such as medication or therapeutic work. How can you make them aware of other bits of life or other impacts that have impacted the client?
Right. So if there isn't going to be a prosecution, then MG19 is not going to be completed anyway. MG19 is only going to be completed and will be of use if there's a successful prosecution, the offender's found guilty and is going to be sentenced. So if there's going to be no criminal case, then it's, you can forget about the criminal justice system.
Mm-hmm.
So your survivor may be able to apply to Seeker, but Seeker has its rules. But if Seeker is satisfied that that person's been a victim of crime, may offer compensation on one of its tariffs, and may feasibly, if there's the evidence, include loss of earnings.
Mm-hmm.
Otherwise, the survivor's left with making a civil claim, but of course that's only going to be viable if there's someone to sue. In other words, the offender's around and is capable of being sued, or those responsible for the offender are around and are capable of being sued. So with a civil claim, then all those aspects that you're talking about, loss of education, the injuries and so on, that can all be claimed for. Okay. So if there isn't a criminal case, then obviously the options start to narrow down. You're left with Seeker, and then you're left with a civil claim as well. But whether they're going to be viable or not depends very much on the circumstances. You've got Seeker, there's got to be criteria, and with a civil claim, there's got to be someone to sue, and there's got to be evidence to support whatever it is that's being alleged. And let's be frank, most victim survivors never get any compensation, either because they left it too late, they've come forward too late, there's no one to sue, the abuser's dead, can't be found, whatever. So, in a real world is that too often survivors leave things far, far too late, but that's the nature of the work, isn't it?
Yeah.
So, but where we have survivors, doesn't matter who they are, we need to be thinking through all of these various scenarios and options.
Thank you, Adam. Yeah, very often people don't disclose for decades, do they?
No.
So the 2-year rule out the window. Okay, let's have another look at the questions. So, Karine, I've never been told about the MG17. I've been made aware of completing another compensation, excuse me, another compensation claim, which just covers diagnosis and treatments and getting the evidence of trauma and where disclosed.
Right.
So, yeah.
Okay. All right. So I'm not entirely sure what you're asking me there, but the process for making a CCO is to use you've got to have your victim impact statement containing as much information as possible, and the police have got to complete that MG 19 with as much information as possible. So, you need ideally a letter from the GP or the psychologist or the psychiatrist or whoever it happens to be, explaining what the diagnosis is, PTSD, what has caused it, what the prognosis is, and what the treatment plan is and what it's going to cost. Without that information, the judge isn't going to say, the judge will turn around and say, I haven't got the information to make an order, so I'm not going to make one.
Thank you. Amy is saying, does this apply to young offenders too? Is there a deadline for MG19s, and what happens when a sentencing happens straight away?
Well, the working backwards, there's no deadline. The police and the CPS need to be ready for their MG19, with their MG19, in the event of sentencing, conviction and sentencing. So they need to be on the ball. So it would apply to young offenders, but young offenders probably don't have the means to pay compensation. So the judge may turn around and say, I can't make a criminal compensation order because it'd be pointless because this 17-year-old hasn't got a penny to their name.
Hmm. Good. That's kind of answering your question as well, Sarah Hart. What happens if the defendant doesn't have the funds to pay the
Yeah.
compensation awarded? Yeah.
It'd be pointless and unfair, if not cruel, to the survivor, because then, it's meaningless. It'd be insulting,
Mhm.
in my
Yeah.
experience.
Thank you, Alan. Laura Maguire, so very informative, thank you. Had a case whereby a male victim was awarded CCO, but was informed this would only be awarded after the offender was released from prison, and by very minimal per week when he starts working. He was then declined seeker as he had been awarded CCO. This sadly stunted his recovery, understandably, as he could not get past this feeling of being wronged. Mm, that sounds,
Interesting.
yeah.
Mm. So, yes, so obviously in that particular circumstance, the judge obviously felt able to make the order. But the tricky bit, of course, is gone and said when he's released from prison and is working.
Mm,
And then of course the court has got the obligation to chase this guy to get the money out of him, and get an attachment of earnings order. In that scenario, if it was really feasible for the offender to pay compensation, I think the survivor would have been helped had they been told that they could take civil enforcement action themselves by getting an attachment of earnings order themselves, um, um, rather than being dependent on the court
mhm.
dealing with all of that. Okay. And with Seeker, I think I would have challenged um, Seeker on all of that and said, well, the reality is nothing's been paid. And of course, under Seeker's rules, if Seeker goes and pays, I don't know, £10,000 out, and then the victim then ends up getting £10,000 off the offender, then fair enough. Seeker could say, can we have our £10,000 back? I
Hmm.
think Seeker went and put the cart in front of the horse in that situation, and they should have been challenged on that.
Yeah, I agree. And what was it that the survivor could have pushed back with in terms of the court collecting the money, Alan? What's that called? A
They
civil?
attachment of earnings order. I think if that survivor had come to see me, I'd
Mhm.
have said, well, rather than waiting for the court to chase around, because the courts can be extremely slow, as we all know, and inefficient, I'd have said, well, this is this is money owed to you. Why don't we go off and get an attachment earnings order for you anyway? And because it's a debt that's owed to you, rather than letting the court fuss around in its
Waiting.
usual slow way.
Yeah, thank you, Alan. That's really useful. I can think of a few reasons to write that one down. Thank you. Okay, we've got Kaylin. May I ask whether a redress scheme applies to the concept of double compensation? So would a survivor be required to notify seeker if they were subsequently compensated as part of a private redress scheme?
Yes, Seeker's rules aren't they? So if the survivor receives £10,000 from Seeker and ultimately then receives compensation for the same thing,
Hmm.
um, what's happened to them from another source, then Seeker are entitled to say, can we have our money back, please? Whether that's through a civil claim or redress scheme or whatever. You've got, if the compensation's been for different things, then there's an argument. But if it's to the same thing, offence A, you've got compensation out of seeker, and then out of a redress scheme, you've gone and got compensation crime A again, then seeker is entitled to say, can we have our money back?
Mhm. Good. Thank you.
But sometimes compensation is paid for different things. So
Hmm.
it's not, the argument can be had sometimes. A redress scheme can compensate for other things other than the actual, sexual abuse. It may be compensating for other things as well.
Thank you, Alan. How you doing for time?
I'm all right. I can, take as many questions as you guys like.
Good. I think there's about 16 left. Let's keep going through them. Thank you for that, Kanan. Thank you. So Ruth has said, could a CCO be applied for after the defendant is found guilty, but before sentencing to stop any issues with being used against the victim? And how can an ISFA best support this process?
Right, working in backwards, when dealing with the police, the ISVA should tactfully remind the police officer, you're going to be doing a victim impact statement. Can we do the MG19 as well, in case, the offender is, going to be convicted and sentenced. So it ought to be done around the same time.
Mhm.
Um, and and remember, it's not the survivor applying. It's not this is the law. The judge must consider making a compensation order. So the obligation is for the barrister, the lawyer for the Crown, to remind the judge that they must consider making a compensation order. And the CPS lawyer must remind the police, we need this information from you, so that it's all to hand when the judge is considering sentence. So the onus is not on the victim. The onus is on the judge. It's from the top down. It's the reverse, so to speak, to seeker, where the onus is on the victim to make a timely application.
Good. Thank you. Sabina is saying, how much does payment of a CCO affect eligibility for seeker? This may have been answered already.
So
Go ahead.
seeker may take into account a criminal compensation order. So let's repeat the example. Let's say it's 27,000 on the tariff.
Mhm.
Seeker may say, well, you've had £5,000 off the offender, so we're going to offer you 22.
Thank you. Yeah. So I'm just looking at the timeline of this, Sabina. I can see that you asked that question about 20 minutes ago. So I'll keep an eye on the time stamp and just
Yeah.
scan some of these, I think. Um, Olivia is asking, at what stage of the process should the police be discussing the CCO with the victim, and when should they be completing the form? I don't think I've ever had an OIC discuss this with the victim. So we're talking about the victim impact statement here,
I
Alan.
think
Yeah.
when the victim impact statement is being done, because the form refers to the victim impact statement. So logically, that's a good time to be looking at the MG19. And you remind the police officer, oh, you need to complete an MG19, don't you? What information shall we get? What do we need?
Mark's coming back in for another question. Thank you, Mark. When do they, and in brackets client police CPS, complete the form? And we've looked at that. Does the defence team know that they have completed the form?
Yes, the defence will be told about that, and my understanding is would see that when they see the victim impact statement.
Thank you. Georgina, got another one thinking outside the box here. Can CCO be applied for outside of the trial if it wasn't previously applied for?
No, it's part of the sentencing exercise. So when the judge is sentencing the offender, that's when it's done. And it's not done at any other time. It's part of the sentencing.
Okay. I've got one from Julia here, and Julia, this is not the first time I've heard this. I doubt whether this is the first time Alan's heard this, and this is along the similar lines to Mark's question that we started off with. So Julia attended a trial where the defence counsel questioned the survivor, about making a seeker claim, and the judge didn't step in to stop that, which they should have done. This was blatantly trying to persuade the jury that the person was seeking compensation, um, rather than, to do with suffering the actual abuse. Given this, I presume the best time to raise the CPO would be at the sentencing hearing, thus avoiding any reference to the SU. the service user seeking to claim compensation. Also, do we need to remind the OIC of the importance of completing the correct forms prior to the trial?
Right, so I think we've covered some of this. So the form should be completed, in my experience, at the same time as the victim impact statement is prepared. And I think it's very unlikely that a defence barrister is going to be shouting about criminal compensation orders when their client is apparently pleading not guilty and is denying everything. Why would the defence lawyer be standing up shouting about criminal compensation orders? Because that's not going to be in his or her client's favour, and is reminding the judge of something that they've probably forgotten about, and that is not is going to be in their client's favour. And but you know, let's say all of this did blow up in the courtroom, the judge would point out and say, well, as part of my sentencing exercise, if your client is found guilty, I'm required by Parliament to consider all of this. It's got nothing to do with the victim.
Mm-hmm. Good.
In the
Thank you,
same
Ron.
way, the length of the sentence has got nothing to do with the victim. You know, the
Mm-hmm.
victim provides a victim impact statement to help inform me, but it's got nothing to do with him or her. The law is I have to pass sentence, and Parliament has said if you commit this type of offence, you're going to prison for whatever. And so I can't. It's got nothing to do with the victim anyway,
Mm-hmm.
and I can't see defence lawyer shouting about this because it's not going to be in their client's interest.
Mm-hmm. Different when it's a pot of money like Seeker, isn't it? That's not directly coming out of the
Yeah, because it's victim
mm,
orientated. You know, it's the onus is on the victim to make a seeker claim. So that's why these lawyers, defense lawyers, go say, "Oh, you're just doing this to try and get some money." But when it comes to criminal compensation order, it's got nothing to do with the victim in the
mhm.
nicest possible way. It's down to the judge. The judge has got to do it as part of his or her sentencing exercise.
Thank you, Alan. Really good distinction there. One to remember as a pushback, or just when we're discussing these options with people. Ruth is asking, how does this the pair work if ordered? So a survivor is worried about, for example, the defendant needing their bank details to pay them. So the money's paid to the
Yeah,
court, then the court pays the victim. Is that
yeah,
right, Alan?
exactly. That's right.
Okay. Assuming that the money is paid to the court, in which case,
Assuming it is. The court has got the job of getting the money out of them.
yeah, yeah, good. Just going to scan some of these. This is an anonymous attendee. Our police special operations, e.g., Operation Hydrant, trained to support this.
The frank answer is probably not.
Mm. But they should be.
They ought to be.
Mm.
Even on their websites, you know, if you go and look at the police websites up and down the country, they go and they're supposed to be providing information to survivors, but the information that they provide on their websites to survivors is usually incomplete and inaccurate. So it gets pointed out to them, but it just goes over them.
Bring it up at the RASO meetings, everybody. Escalate as much as you can when you're working with the police on this one. Let's have a look. Oh, interesting. Stella, thank you. So, have you ever dealt with any cases where the victim applied for COO or seeker or CCO or seeker in relation to digitally facilitated crimes, such as things like intimate image abuse, online exploitation, etc.? And what has that been like?
Well, I'm not aware of any CCOs being made in respect of that type of offending. Um, so that's why I'm saying you've got to think outside the box all the time. With Seeker, I have seen awards being made, but it's often been accompanied with other forms of sexual abuse.
Mhm.
But Seeker applications can be made for that particular category in its own right, and there's no reason why a CCO cannot be made for that category of abuse either.
Good, thank you. I feel like we're maybe coming to an end here. I'm just going to scan some of this. Um, no, the rest is just thank yous, and there is something there that we've already answered. So yeah, that's wonderful. We have gone slightly over, so I appreciate your time, everybody. Thank you for joining us today, and a massive thank you from you, Alan, as well, for your
Thank you
time.
for having me. Pleasure to be here. So thank you for having me. And I will send on the PowerPoint and the MG19 form. So I'm sure that can be shared amongst you all.